Great. And Justin, you have the floor. Thank you so much for programming this.
Thank you, Linda. Good afternoon, everybody. I'm happy to be here to introduce Henry Peacor, who's going to be giving us a wonderful presentation on advanced deposition techniques. This is through the litigation section. You may remember that earlier this year, I did a webinar on the nuts and bolts of depositions. So this is intended to build on that and take it even a step further. Henry Peacor is a partner at Trial Lawyers for Justice. He is one of their trial lawyers. They're a national trial firm, handle cases throughout the country. It was founded by Nick and Courtney Rowley, who also host a trial by human seminar regularly throughout the country, at which Henry is one of their teachers and very experienced, great trial lawyer. He and I think, share sort of a mentor with Nick Rowley. And so I consider Henry almost like a brother from another mentor. So Henry, thank you so much for being here and doing this presentation on advanced deposition techniques.
Absolutely, my pleasure, and good to see you, Justin. And thank you to everyone for tuning in during what might be your lunch break, I would imagine. So let's get right into it. I'm going to pull up the presentation here. And of course,
So let me interrupt for 1 second. Let's just mention if any questions, put them in the chat box and Justin will review them. So feel free to go to the chat box. And with that, thank you, Henry.
Of course. Okay, so we're here to talk about advanced deposition techniques. And let's see, here we go. So an overview, where we're at, where we're going. We're going to talk about common mistakes, how we prepare for the deposition, how we begin the deposition, cases you must know, must have handy for when you're taking a deposition. And then we're going to get into the advanced questioning techniques and how to handle the opposition. Okay, so common mistakes that I often see a lot of times, as Justin was explaining, I'm coming into a case on the tail end, getting ready for trial. And so a lot of the depositions I'm reviewing have been taken by other attorneys, other law firms, and I inherit the situation. And so here are some of the most common mistakes I see being made, and it'll kind of segue nicely into what we want to do as we're getting to a more advanced level and more experienced level of taking depositions in cases, whether that's California, Iowa, Washington, those are the states I'm licensed in, or throughout the country. I have cases as far east as New York and Massachusetts, South Dakota. I had a mistrial in South Dakota, Missouri, all these other places. How do we fix these mistakes and get better? All right. One of the most common mistakes I see are waiting too long to take the deposition. So we often think that we need all the documents. We need the entire outline ready. We need discovery responses that are answered under oath and penalty of perjury. And we need all of this information in order to start taking depositions. We need to know. We need to know all this stuff so that we're not guessing when we're in the deposition. And I think we're missing a big opportunity. So in California, what's the earliest we can take a deposition? Well, the earliest we can take a deposition is 20 days after service of the summons on the defendant. And so when I'm involved in a case from the very beginning and we serve that complaint, we serve that summons on the defendant, I am calendaring 20 days later in order to be able to serve them with the notice of deposition. I'm noticing it as soon as possible. I want first bite at that apple before they start deposing my client. I may not have much information. I may not have all the documents that I quote unquote need to take a good deposition. And that is what often leads to the most powerful depositions and the most powerful presentation of evidence. And let me give you an example. We have a motor vehicle collision, and maybe I have a police report, and I go to take the deposition of the defendant driver who was working for a corporation at the time of the collision. And I don't have his employee file. I don't have any understanding of prior disciplinary actions, any statements that he gave to his employer, just all this information I would love to have. So I go into this deposition and I drop this need that I used to have of being perfect, perfectionism. We're going to talk about that. But I drop that and I go in and I just go through what happened in the crash with this witness. I get admissions and concessions where I can. We'll talk about that as well. But he gives me, or he or she gives me this explanation about what occurred. And later on, I get this influx of documents and other records and evidence. And lo and behold, they're inconsistent with what this witness said at their deposition. Now I have impeachment. Now I have good impeachment that the other side can't clean up or fix or plan around or coach around or focus group or talk about or have an explanation for. I got them dead to rights. Because if I don't have this information, chances are the other side doesn't have that information as well. And I know going in that I'm going to be able to get some things, and people, they tend to lie when they don't have the documents that say what they said on a prior occasion. So go in, take the deposition, and really drop this idea of being perfect. We all think that when we're taking a deposition, we have to ask all the right questions. We have to talk about every single thing. And what ends up happening are these long-winded depositions that can take 2 or 3 hours when I'm taking a deposition in 20 minutes or less. We're going to talk about how to do that. But if I'm in a deposition and I'm starting with the usual admonitions, background information about the witness, and I'm easing into the topic, and then we're talking all about it, and I'm revisiting subjects, and it's a 3-hour deposition, there's not many useful pieces of that depo, or when we're getting ready for trial, the actual useful pieces are very small. Get in like a surgeon. Be very, very intentional and specific with what you're trying to establish. Is this person a witness who falls into the liability category? Are they a damages witness? Let me orient this witness into my overall case. What are they here for? What am I trying to establish? What are the 2 or 3 goals that I have? And if you get in and you get right to the heart of the matter, and you establish those 1 or 2 topics or those 1 or 2 concessions that you need, and you get out, it creates an impression on the other side that you really know what you're doing and that you're confident in what you're doing. If you're wandering and you're taking these long depositions, it creates the impression that you don't know what you're doing. So drop the need to be perfect, get in there, be intentional, and understand that 99% of your depositions are never going to see the light of trial. They're never going to go to trial, right? You can make mistakes. If you forget to ask a certain question and afterwards you have, buyer's remorse and you're thinking on the drive home, oh man, I should have asked that question. I can't believe I forgot to ask that question. Well, send a follow-up special interrogatory, right? Save it for trial. You don't need to have everything all the time. It creates a tremendous amount of pressure on yourself, and you end up waiting too long to take that deposition that you should have taken much earlier. And when you take depositions earlier in a case, you're also creating leverage that will help you settle and resolve cases earlier in the litigation lifespan. All right, so we need help. If this is our problem, how do we get better? How do we improve? How do we advance our techniques in taking depositions? One area is the preparation, right? And that's going to be very specific to your area of law, the type of witness, and so forth. But preparing is key. Like I said, we want to identify the landscape of our case. If I have liability, causation, damages, which category is this witness falling under? What do the jury instructions say about that given topic? So if I'm in Iowa, the jury instructions on damages involve loss of function of a bodily part, versus California, it's loss of enjoyment of life and and fear, anxiety, emotional distress. And so there's a difference in the law. Well, I need to check those jury instructions and orient my questions within those instructions, within the law that applies to the case. And if I'm asking an expert or a lay witness certain questions, I'm framing it in a way that satisfies my burden of proof. Is it more likely true than not true that this happened? Anytime they say, oh, I'm not certain, it's okay. You don't have to be certain. The question is it more likely true than not that you had X, Y, or Z? So framing the questions within the jury instructions is a big part of my preparation, and also orienting the witness to where they are in the overall picture of the case. Admonitions. So what we all learn as young attorneys or new inexperienced attorneys is here are the admonitions that you give at the beginning of every deposition. You understand that you're under oath, that your testimony here today, even though it's in an informal setting of a Zoom video teleconference, your testimony here today has the same force and effect as if we were in a court of law in front of a judge and jury. You understand that? Yes. Answer verbally, no nodding or shaking of the head, no saying uh-huh or uh-uh. We need verbal responses, yes or no. Do you understand that? And we go through the list of about 10 admonitions. And what that does, it's a couple of things that does. Number one, the witness becomes comfortable, right? This is a long-winded process giving these admonitions. It takes about 5 to 10 minutes, and they start to become comfortable in the setting of the deposition. Number two, you're reaffirming the credibility of their attorney who prepared them for today's deposition and said, hey, the way the deposition starts is the same way that every deposition starts. It's with these things called admonitions, the rules of a deposition. So this opposing attorney is going to ask you all these things or tell you about these admonitions. And so when you start down this path, that witness is sitting there and going, oh, my attorney told me about this. And that's exactly what's happening. Gosh, my attorney's really good and really solid in preparing me. And I feel really prepared because this deposition is starting exactly the way my attorney told me it would. And we're missing a huge opportunity. I do not start, so I use admonitions as a sword throughout the deposition if needed. But generally, the way I start a deposition, state your name, you understand you're under oath, penalty of perjury, testimony here today has the same force and effect as if we were in a court of law in front of a judge and jury. You understand that? Yes. All right, we're here to talk about a car crash. Do you admit to being at fault for causing that crash? I get right to it. We're here to talk about, a family matter, employment matter. Do you agree that X, Y, and Z? And I get straight into it. And it doesn't waste any time. It gets right to the heart of the matter, gets right to that category of liability, causation, damages, wherever I've placed this witness. We're going to talk about that and we're going to get right into it. And then throughout the deposition, if they start saying, I ask them a question, they say, I don't know, I don't remember, I would be guessing. Well, then I'll give them the admonition and I'll explain to them that, the difference between a guess and an estimate. So it's okay that you may not know something, but unlike a cocktail party, like at a cocktail party, if I brought up a uncomfortable topic, you might say that you don't know and move on and change the topic. But here in this proceeding that is so important that it carries with it the penalty of perjury and that oath that you took at the beginning, this procedure is so important that even if I ask you a question that is hard or difficult or that you don't want to answer, you still are required to answer under the law to the extent that you know or that you can make an estimate about what happened. And I raised the stakes of that question. I raised the importance of that question. I raised the meaning of that question. And by explaining this and giving that admonition at that point in time, the witness is educated on the importance of it. And so if they then stick with, I don't know, I can't remember, they lose credibility. right? And that's where we use admonitions throughout the course of the deposition itself, rather than giving them right at the beginning and going through that laundry list of admonitions we have to give, or we think we have to give. You don't have to give them. Try it. Don't do it. Wait. All right. Cases you must know. Couple really simple cases to know for any deposition. I hope I picked cases that are, regardless of topic area, whether it's family, probate, personal injury, contract, employment. Hopefully these cases apply to all of them. We'll see. But there's nothing more powerful than when you can cite a case by name in the middle of a deposition. If you're having a meet and confer with opposing counsel and you drop a case name from memory, or you have it written down, there's nothing more powerful than that. It creates such an impression. So here are some cases you must know. The first is Stewart versus Colonial Western Agency. And this really stands for the proposition that you can ask just about any question, and the witness is required to answer under the law unless that question calls for something that is privileged or private, right? So when I ask that question at the beginning of a deposition and I say, do you admit that you did something wrong? Do you admit that you're at fault? Do you admit that you were negligent? Objection, calls for a legal conclusion. Blah, 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 blah. Yeah. Okay, thank you, counsel. Sir, do you admit to being at fault? It's a perfectly acceptable question. They're required to answer. They're not being instructed to answer because it calls for a legal conclusion. It calls for nothing privileged. It calls for nothing private. It's their understanding. Do you know what fault means? Do you know what it means to be at fault for something? Do you know what it means to be negligent? Maybe they don't. Okay, let me attach the jury instruction defining negligence. This is the definition that would be read to the jury. Let me define it for you. Failure to use reasonable care. So did you fail to use reasonable care when you were operating your vehicle and rear-ended my client, right? And push with these questions. Don't get flustered by opposing counsel, raising the heat in the room or raising their voice, right? You have a right to ask these questions, stick with them, as long as they don't call for information that's privileged or private. The next case is Stony Brook versus Superior Court, Stony Brook and Allen. And really, this is about money and bias. So any expert witness must answer questions about their income, how often they testify plaintiff versus defense, how often they've worked for this specific attorney or their law firm. All that information is relevant to bias. So a lot of times people have a privacy interest in their financial income, but what these cases stand for is the proposition that when an expert or a person, just anyone, does a lot of litigation work and they put themselves out there and they're making money from doing this work, they therefore give up their privacy interest in that financial information. So push, get that information, establish the bias of hired witnesses. Kennemer, this is your classic case that many of you are aware of. It's about avoiding surprise at trial. When you have an expert witness, you're entitled to their opinions and the basis of those opinions. And if you ask these questions, you have to ask the Kennemer question the right way. There have been many times at trial where an expert is up on the stand and they're giving an opinion and someone says, objection, Kennemer. And the question becomes, from the judge's perspective, was where are the Kennemer questions asked in the deposition and what was the response? And the Kennemer question is just simply, have we now discussed all the opinions that you intend to give at trial? Have we now discussed all the bases of those opinions that you intend to give at trial? If the answer is anything other than a yes, then you have to follow up with, okay, what's your next opinion? What other opinions have we not discussed? Please tell me what additional opinions you have. You have to keep going until you get an unequivocal yes to that question. You may see experienced experts say, oh, that depends, counsel. I've shared all the opinions I intend to give at trial to the extent you've asked me a question about those topics, but I can't anticipate what questions I'll be asked at trial. And I don't know if counsel will ask me to do more work after this deposition. I may review additional deposition transcripts later on. Okay, fair enough. But sitting here today, as we sit here today, based on your report that we went through, the opinions you've shared, as you sit here today, are there any other opinions that you intend to give at trial? No. Boom. There's the record. That's what I need. That's what I need to establish. And I keep going until I get that yes or that no. That's very clear in establishing the record that this is everything the expert intends to give at trial. The last case here is Emerson Electric. And really, this one of the best things that you can do in a deposition or at trial with a witness is put the case into action, create movement, use demonstratives, make it, our attention spans are constantly getting shorter and shorter. And in order to keep the jurors' attention and to keep your own attention in the case, putting things into action really is powerful. So this case stands for the proposition and allows us to ask the witness to reenact something, to draw a diagram. Oftentimes for me, I have a lot of motor vehicle collision cases. I might print out a Google image of the crash location and say, please circle where your car was located. Please circle where my client's car was located. Mark an X where you were in the sidewalk. Do this, do that. And I put it into action, and then we attach those exhibits to the deposition. You have an expert. You may ask them, show me, biomechanic expert, show me how my client's body moved at the moment of impact. I'm going to clap at the count of 3, and I want you to show me how my client's head moved in the headrest, right? Put these things into action. It creates an incredibly persuasive presentation. And the best example of that, I'm going to play a clip here from trial. This wasn't in the material shared with you, but we can certainly make it available. You may have heard of the Starbucks case that was tried earlier this year, where my partner, Nick Rowley, who Justin also mentioned earlier as one of his mentors, tried a case against Starbucks that resulted in a $50 million verdict. And the case was about hot tea. It wasn't about coffee, but hot tea that was put into one of Starbucks's cups, and the lid was put on top of that cup. There were 3 cups of hot tea, scalding hot liquid, about 180 degrees. And what happened is the barista who was working at Starbucks was putting the hot teas in a carrying tray, like you often see, right? Made of cardboard, 4 distinct places to put the hot tea. And what you see in the video is that she puts the first one in and puts that leverage on top and pushes it down, and you can kind of see it settle in. The second cup puts it in, pushes it down, you can see it settle in. And the third cup she puts in, and it's at this angle, and she doesn't push it down, and you can see it's kind of above the other cups. And then she hands it to the customer. His name was Michael. And Michael grabs the tray, and as he's putting it over his lap, the tea spills right into his lap, and it burned his penis very badly. 3rd-degree burns, multiple skin grafts, loss of function, loss of girth, length, everything. He's 25 years old. He's been mangled from this injury. And so the clip I'm about to play you is from a witness who was first introduced at trial. And what you'll see is Nick's cross-exam here, and it's 7 minutes. That's it. And he's putting the whole series of actions that I just described, he's putting it into action to show how ridiculous the witness's position actually is. So I'm going to play that for you. It's about I think maybe 5 minutes long here, and hopefully, I think the quality clears up as the video plays.
Hello, we met.
No,
My name's Nick Rowell.
nice to meet you.
Nice to meet you. So you've been with Starbucks for how many years?
It'll be 8 years on April 17th of this year.
Happy with the company?
Yes,
Time to stay?
hopefully.
Keep moving up?
Yeah, you can see what I was planning.
I just heard you say something. You also said it in your deposition.
Maybe your depot was taken.
The employee who put those 3 cups in, cup 3. According to you or what you said under oath. You wouldn't have her do anything different, would you?
I'm sorry, can you repeat that? I don't understand.
Yes. In your deposition, we asked you, do you wish she would have done anything different after watching the video? And you said no, correct?
You mean today or in the or during my deposition?
During your deposition under oath, which was taken on July 8th of 2022, we asked you if you, after looking at the video, and you investigated this matter, we asked you if you wish that the barista or the gal who put the cups in had done anything different, and your answer was no, correct?
Yes,
And what you just said here today is that, and you're one of the higher ups at Starbucks, you were the manager, correct?
yes,
And according to the manager, and you represent the corporation, corporate policy, true?
I am the store manager I was a store manager at that time, yes.
And you represent the corporation, yes?
As the store manager, yes.
And corporate policy, true?
It depends.
Life foundation. Sustained. And you just told this jury that you don't think that the person that worked under you did anything wrong, correct?
I believe she did her job to the full potential, yes.
She did everything right.
I do believe so, yes.
So it's okay with you if scalding hot drinks, and it's okay with Starbucks, if scalding hot drinks are handed over to people not being completely secured. That's okay with me. Objection. Overruled. Yes,
Can you repeat the question?
yes, is it okay with you? I'm gonna. Come on. You would agree with this? There's a right way to do things and there's a wrong way to do things, true?
Yes,
There's a safe way, there's a dangerous way, true?
correct.
And when we're dealing with scalding hot drinks, we want to make sure we do things safely, true?
Any drink that Starbucks sells, there's a certain way that you have to handle it, whether it's hot or iced.
But we're
And it
talking,
should be, specifically in this scenario, yes.
you want to be safe, correct?
In any capacity, yes.
Because if you don't put something in right and it's loose, it has a risk of spilling, true?
I didn't say that.
You agree with me that if you don't put something in right, and it's scalding hot, that it has an increased risk of spilling. True?
No,
It doesn't?
no,
If you don't put something in right. So this one, that's in right, correct?
yes,
That's in right, correct?
yes,
This one. Is that in right?
now it is.
Okay? And now it is, if it's scalding hot, is it safe?
All drinks seem to be secured in the cup holder.
If it's scalding hot in there, is that safe? Yes or no?
Now it is. Sticking up, it wasn't.
Cause he wants you to answer the question when the cup
Right here.
is up in the air like
Is
this.
it safe now?
No,
And if it's filled with a scalding hot drink, that is at an increased risk of severely burning someone when it's put in that way, right?
Correct.
You wouldn't allow someone to hand someone a drink like that, would you, if it was scalding hot?
It's not in the cup holder for it, so no.
Because that would be a risk for causing that customer to be burned, true?
Yeah,
Okay. Please hand it to me.
can you put the tray back down, please?
Sure.
Okay.
I know you want to put it back, I know. Thank you, I appreciate it. Go like that. No. Scalding hot liquid in there. Will you hand this to me, or would that be against the protocol?
Well, the drink should be secured and then I would hand it to you.
Thank you. All right. Then why wouldn't you hand it to me if the drink wasn't secured?
What do you think?
Because.
Because it would, if the drink wasn't hot, if the drink wasn't secured, then it could potentially cause, an accident.
Now, I want you to assume something for a minute.
Okay.
It's like this. Okay, it's scalding hot. See the difference? Two? That's not okay, right?
There are not levels, so that is correct or not.
I want you to hand it to me anyways. I know you don't want to, because it's not safe and maybe you care about it. But I want you to hand it to me anyways. Okay? All
Now?
right, yep.
Okay.
Assuming there's scalding hot liquid in there. Now, if you handed it to me like this, let go. There's scalding hot liquid in there. And it wasn't put in right. And now it spills within 1.4 seconds. You'd accept responsibility for that, wouldn't you?
No,
You would.
no,
Why?
because I'm not sure, like, what would happen, how would I accept responsibility for something for that?
And is it Starbucks corporate policy that once your hands are off of it, it's on me, no matter what, it's my fault, it spills and not yours?
Section.
There's nothing in our policy that states that I can recall.
Well. Thank you. It's nice to meet you. Those are all the questions I have.
Okay, so read.
All right, so that's 7 minutes. I mean, the case is over, right? After that cross exam. We're here to talk about depositions. So a lot of that, what you just saw, could be done during a deposition. It may be a reason to take a deposition in person, right? Is to have the witness demonstrate what occurred. But as you can see from that cross exam, I mean, the case is over in terms of liability. That was a 7-minute cross examination. It got right to the heart of the matter. It didn't waste time with education, training, experience of this witness and her history with Starbucks, other than to say she's been working there a long time and she plans to continue working there, which shows some bias, right, about what her testimony may be. But you also have a question of why. Why wouldn't it be safe to hand this over, right? Sometimes we're taught that you never ask a witness the question why in cross-exam. That's, in my opinion, outdated, right? There are certain instances where that's exactly the right thing to ask. At a deposition, I always write at the top of my notes why, and I circle it. I want to know the reasons, and I want to know them early. I hopefully get to know them before trial, but you want to get that out there so that you know what you may be facing at trial. And so you've given the witness time to potentially explain themselves. But again, putting things into action, incredibly persuasive. And if this was a more interactive process and I could see you all, I'd want to know how many of you felt the impact of that testimony, that cross exam, and the demonstration when it comes to Starbucks's liability for putting the cup and securing it safely in the holder. So let's talk about some advanced questioning techniques. That's why we're here. And the funnel approach, right? And we kind of saw it in that video, but we want to start broad, right? We want to start with general principles, right? So even before getting into how that employee did what they did, it's like, let's just talk about a hot liquid. Let's talk about securing it appropriately. whoever your witness is, start with general topics and principles about the topic that you're about to get into, right? You want them to agree. It's an agreeable process. You're looking to get favorable testimony, right? You're looking to get admissions, concessions, what I often call areas of agreement. Sometimes I will categorize my questions for a deposition into areas of agreement and areas of disagreement. And I may start a deposition by saying, look, we're going to talk about a number of different things, but let's see if we can start with some areas of agreement first, right? And get those concessions. Another example of this, so for cross-exam of an expert, I may start by saying, expert Mr. Smith, you would agree that an expert should be fair, impartial, and objective, right? Right. You want to be fair to both sides. True, true. And the reason why that's so critically important as an expert is because you possess certain education, training, and experience beyond that of an average layperson that gives you a sort of power within your area of expertise to talk about certain topics in a way that goes beyond that of an average layperson, right? Right. And that's an incredibly important responsibility as someone with that power that comes from your education, training, and experience that allows you to be the expert that you are, whatever that expert is. Right? So it's critical to be fair to both sides because you know that the jury here, these average lay people, they may rely on your testimony in determining important issues in this case, right? Right. So that's why it's so important to be fair and impartial, to be comprehensive, to not just include things that are beneficial to the side that hired you, but also to include all the information, even if it's information that may potentially hurt the side that hired you, right? You want to call it like you see it. You just elevate the importance of being fair and objective and impartial for this expert. And then you may say to this expert, have you ever heard the saying, actions speak louder than words? Yes. And what that means is that if we want to know how someone truly feels, what they truly believe about something in their heart of hearts, we look at what they do, not just what they say, right? Right. Like talk is cheap, but actions, they matter, right? Right. So we have your words about being fair and impartial, objective, giving both sides equal weight. Now let's look at your actions in this case. And boom, now I've set up my cross exam to look at how they omitted certain information from their report, how they highlighted certain things, how they maybe got argumentative in an area. And at any point in time, if I'm pushing for a concession or we're into a topic and that expert starts to fight with me, argue with me, get defensive about something, I may say to them, hold on, are you advocating for the side that hired you? Are you being fair and impartial when you say that? Were you being fair and impartial to my client, Mr. Hernandez, when you failed to mention that he suffered an asthma attack or whatever the topic is, right? That's how we set up these powerful cross exams and powerful witness testimony. Commitment and constraint questions. So these are three essential questions I always am writing down and making sure to ask. And here they are. The first one, is there anything else? Again, Kennemer for experts, right? But also just any other witness. Is there anything else you want to say here today? Give them that opportunity because later on, right, when they've been taken to the woodshed by their attorneys or they've been prepared or they've gotten new additional information and all of a sudden you take a witness who couldn't remember anything at their depot and they show up at trial and they remember all this stuff. Asking these kind of broad questions invites the opportunity for this witness to share what they got at that time. Create inescapable positions. We saw that with the video clip we played. hindsight 2020, polarize the case. So, and we heard this in the clip too, but at the end of every deposition, especially if it's a party who I'm deposing, it's the other side, I will ask them, knowing what you know now, hindsight being 2020, if you could go back and do it all over again, would you do anything different? No, right? As we heard that woman say, oh no, this Starbucks employee did nothing wrong. She did everything, to the highest potential or whatever she said, right? Lock them in, polarize the case, create that extreme, polarizing the case means we're not going to allow witnesses to stay in this ambiguous equivocation of yeah, a little bit of this, a little bit of that. Areas of gray, those aren't those are those aren't that's not the recipe for a good verdict, for a good result, for a good outcome. We want to polarize the case. So you're saying that this was safe. You're saying that she did nothing wrong. You're saying that this is secure. You're saying all of those things that you just saw in that clip, that is polarizing the case, because when you watch that witness say that it's not her fault, it's not Starbucks' fault for handing over a drink that's askew and not properly secured, after she personally kept securing it and saying, now it's safe, she loses all credibility. And that jury can see exactly what's happening here, which is you have someone who's employed by the defendant who doesn't want to lose their job. That's their bias, but who cannot help but admit that what happened was wrong, or on the opposite side saying just, yeah, that's not our fault for handing over a drink that way. It is so extreme that there is just no getting out of it. And not surprisingly, the jury came back with 100% unanimous verdict on liability against Starbucks in that case. All right, building chains of admissions. Again, we're establishing foundational facts, connect to related admission, add temporal or causal link, and reach inevitable conclusion. Okay, so an example of this might be, for me at least, with personal injury is, everyone has pre-existing conditions. We all have degeneration in our spine that occurs as we age. And a lot of times I'm going up against the defense and they are saying that it's pre-existing. And what I'll do is I'll go through that and I'll talk about the fact that everyone is a pre-existing condition. Everyone has some level of degeneration from the moment we're born. We start degenerating, we start dying, right? This process of dying, that's my foundational fact, right? Then I'm going to connect it into the jury instructions and admissions. Okay, so you're saying that my client had this pre-existing condition, right? You're saying that she had this. And with the jury instructions, it's like that makes them more susceptible. That makes this an eggshell plaintiff. We have an aggravation of a pre-existing injury or condition. I will get admissions about what that means for my client. And then I'm going to the medical records and I'm establishing the temporal or causal link between the moment of the incident, whatever that incident is, and my client's symptoms. And establishing that causal link to the incident, not some history that does or doesn't exist to whatever extent it is. And that allows me to reach this inevitable conclusion that to the extent my client had any pre-existing condition, degeneration in their spine, whatever it may be, it made them more susceptible to injury, and it was aggravated as a result of the incident, whatever it may be. Those are the things I'm trying to establish, and that's how I get there to that inevitable conclusion. Okay, so documents, as we're getting documents in, again, we don't want to wait on document production before we take these depositions. Go forward, be confident. You know your case, you know what you need to prove, you know what you need to establish. Go get that witness's version of events before it's been, refined after years and refined with all information. But as we get documents in, so in my example of the driver who I didn't have the employee file, I didn't have his prior statements, which were inconsistent with the version of events I'm getting now. I am establishing whatever his testimony is here today and I'm establishing it as extreme a way as I can, polarizing it as much as I can. So again, hindsight being 2020, if you could go back, would you do anything differently? No. Okay, no. So then let me go through their specific actions. So you're saying that what you did in this exact moment was the correct thing to do. And that if I were to put you back in that position and give you the opportunity to do something differently, knowing what you know now, you're saying that you would do the exact same thing in the exact same way. There is no bad answer to that question. If they say, yes, I would do it in that exact same way, we've polarized the case and they've lost credibility because it's extreme. If they say, no, I would do things differently, here's what I would do differently, well, guess what? That's helping support my claim that they're at fault, that they did something wrong, that they did something they should not have done, and that they failed to use reasonable care, right? So that's what we want. That's what we need. A lot of times, if I have something like a very clear prior inconsistent statement, I may not bring it up at the deposition. I may keep that up my sleeve and save it for trial, knowing that I'm going to be able to do that at trial, rather than give the witness the opportunity to explain away why they said something different then versus why they're saying something different now. Okay, dealing with evasive witnesses, people who answer the question but add a long explanation, I will move to strike that answer in the deposition. I'll say, thank you, I'm going to move to strike as non-responsive. There's no judge in the room, so I don't know if the judge is going to grant or deny that motion, but I'm going to make it for the record. My question was different, right? And I'm going to stay persistent with that question till I get a yes or no answer. And the more defense counsel or opposing counsel objects, asked and answered, whatever they want to say, the question still needs to be answered. And I'm going to stick with it until it's answered in the way that I want it to be answered. To the point where I will write down my question on a piece of paper and I'll create a box that says yes or no. And I will attach it as an exhibit. I say, you know what? Let me simplify this because I think there's something happening. It's a miscommunication of some kind, but it doesn't appear that you're understanding my question. And maybe that's on me. Maybe I need to do a better job asking a clear question. So let me write this down. The crash was my fault. Mr. Smith, signed by Mr. Smith. Now make it quotes. You're Mr. Smith. Here's your quote. True, false. Mark and attach as the next exhibit. Sir, I'd like you to check the box that represents your answer. Right? And I'm going to stick with that until I get the answer I need, or I get some ridiculous exchange that's going to help my case anyways, in any event. When a witness gives you, breaking down compound evasions, when a witness gives you this long diatribe of an explanation, the first time I'll kind of let it go, because a lot of times if you give someone a rope long enough, they'll end up hanging themselves with it, right? And when people are defensive or they're offering up explanations, there are often kernels of truth in there and kernels of inconsistencies that you can pick out. So at a depo, I may allow them to surface a lot of that, and then I'll follow up in the precise areas of what their answer was. You know, you said 3 things there. I'd like to address each one in turn more specifically. First, you mentioned X. Before you mention the rest of it, I just want to focus on X. Is that true or not, right? And I'm narrowing it in so that I have what I'm hoping will be good sound bites, good, clean testimony that I can excerpt for trial, put in a opening statement presentation, or use with an expert, or use during trial when that witness is on the stand. I want my sound bites. I need that clear testimony, and I'm not going to stop until I have a very clear record. Using the record strategically, yeah, we're making clear statements on the record about witness behavior. I'm doing it kindly. That does not mean I'm rude. I'm kind, I'm professional, but I'm going to be clear about what's occurring. Sir, you just looked at your attorney there. I need you to look at me when I'm asking this question. He can't help you right now. This question is for you, right? If we see a witness looking at their attorney, for some indication of what the right and wrong thing is to say. So those different things we'll do and point out during a deposition. And I video record, I would say 95% of my depositions. It's rare that I don't. I want that demeanor evidence. I want the tone. I want the pausing. A deposition, if I pause mid-sentence and then continue, the deposition just reads, like I said, a full and complete sentence without hesitation, without, looking like I'm unsure. But in a video recorded deposition, you get all of that color that comes with testimony. And that's where the most persuasive evidence is. Let's talk about how to handle the opposition. I mentioned this a little bit with attorneys, opposing sides raising their voice or arguing with you. Establish your record, have cases that you're ready to cite that permit the question you're asking, especially if you know it's a hot and contested issue. And address them to the extent you feel the need to. But one of the most powerful methods I've discovered is to not say anything to the other side. Silence. Silence is incredibly powerful. And you'd be so surprised at the power it creates when you don't acknowledge what the other side is saying, right? So, sir, tell me about this. Objection, calls for speculation, lacks foundation. You can answer if you know. Sir, right? Well, if you can answer if you know, that kind of sets up the witness to answer the question. But if the other side, objection, this, that, the calls for a legal conclusion, this, that, blah, blah, counsel, that's an inappropriate question. Okay, blah, 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 yeah, yeah, yeah. And I'll just hold out my hand. Sir, your answer, please. Oh, I forget the question. Okay, Madam Court Reporter, could you please read back my question? Same objection, same objection. Okay, sir, please answer my question. What's your answer to that question? And it really establishes power dynamics. As you know from doing this, there is a spoken and unspoken battle that is occurring through body language, eye contact, tone, demeanor, all these intangible things. And it is important to do your best to give yourself the leverage to win that battle, right? We often come out of depositions with the feeling of ickiness, like that did not go my way today. I was really off my game today. Oh man, that other attorney seemed really on it. And I think in this war of battles, of individual battles, maybe they won 4 and I only won 3. And so advantage them. Well, we want to use every tool in our toolbox to help give us that advantage in this power dynamic, the confidence in our case, the appearance of our case, in addition to the substance of what's being said. And so sometimes, again, being silent, letting a witness ramble. Sir, I'm sorry, that wasn't my question. I'm going to move to strike as non-responsive. You get the transcript and they went on for 2 pages with their explanation, right? It creates a power dynamic that will serve you moving forward. Be kind. Be kind. Number one piece of advice I can give is to be kind. There is nothing more devastating and more powerful than dismantling the other side with kindness. And you saw in that video clip, thank you. It's nice to meet you. It's nice to see you again. Ma'am, we haven't met before. It's nice to meet you. Right? Polite. Be polite. And when you dismantle someone with kindness, it is so, so powerful. And then feel free to contact me. That's the presentation. I want to leave some time for some questions. But if anyone would like, you can also reach out to me and we can talk about any specifics as well.
Henry, wonderful presentation. Thank you. We did have a question in the chat about Emerson Electric Company, the case that says you can make the witness do demonstrations or draw diagrams, things like that. So you mentioned that you videotape most of the depositions that you take. How might you use the Emerson Electric case if the videographer doesn't show up and you have to do it without a videotaped record?
Sure. So without a videotaped record, I may have the witness mark something on the map, fill out something. look at a photo and mark where they were standing at the time, right? Mark, because oftentimes what you'll see is they'll mark a place and it's like, oh, from that perspective, you can't see anything. You can't see what happened. You can't see what occurred. So what's the legal ground for it? Is that what the follow-up question is for marking it? I mean, it's the Emerson case, right? And you can look up the specifics of that case, but what that case, and I'll pull up, let's see exactly what it said here. Deponents can be compelled to provide nonverbal responses at videotape deposition. So it does say videotaped, including physical demonstrations, reenactments, and diagrams. So the specific facts of Emerson, you may want to look at it. But again, this recognizes what the case stands for is the proposition that testimony is not just verbal. It can be marking a location. It can be doing something visually that helps us understand. You know, sir, when the crash happened, where were your eyes? What happened? Or, you know, in a contract or employment dispute, you may bring up the actual document. Can you mark what section we're talking about here? Can you put your name next to that section? Is this a section you agreed to? Is this a section you agreed to now? Would you please put your name there with today's date and say, I agree that this principle applies, right? Try it. Here's the other thing. One of the big points I wanted to make today is try different things. Do not be afraid to try things that are out of the box and different. And I'll give you a quick example. I was taking my first expert deposition. I was around Joey Lowe, whom you may or may not know. He teaches at the Trial Lawyers College. Incredible attorney. And he goes, Henry, you're taking your first expert's depo? First question out of your mouth before you've asked anything. Ask that expert, when was the last time you told a lie? And I was like, oh man, I don't know if I like what's going to happen. So I asked this question. I go, when was the last time you told a lie? Objection, blah, 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 blah. And the expert was like entertained by the question. He was like, no, I'll answer it. I'll answer it. He's like, last time I told a lie, I was probably like 5 or 6 years old and I had taken a piece of candy from my mom's cupboard. I said, okay, so you're telling me that you haven't told a lie since you were 5 years old. And how old are you now? You're 40, 50, 60. So in the last 45 years, not a single, like it just immediately created this dichotomy where this guy's not really sounding that credible because he's saying he hasn't lied since he was a kid. Right. So have fun. Don't be afraid and push. And if at the end of the day, the witness refuses to answer, mark the question and then make a strategic decision later on whether or not it's worthy of filing a motion to compel. Right.
That totally polarizes the case. No one's going to believe someone who says they haven't lied since they were 5 years old.
Yeah, that's right.
Awesome. Well, I think that's all the questions we had. And this, like I said, has been a wonderful presentation. By the way, Henry, can you tell the folks who hadn't heard about the Starbucks case, what was ultimately the verdict in that case?
Yes. So the verdict was 50 million. What happened, interestingly enough, is they offered 30 million during trial. And we almost accepted, but we asked them to apologize and to issue a statement to all Starbucks's, a brief memo. They could draft it themselves, explaining or saying to all Starbucks owners and franchisees and all that stuff that their lids need to be properly secured. Take the extra time to secure the lid. And Starbucks refused. And so the case went forward to verdict, ended in a $50 million verdict. And 3 of the jurors were crying because they wanted to award more. And that case was incredible, filmed on CVN, and really, we were looking to reframe hot coffee cases. If you know McDonald's case and the documentary that came out, Hot Coffee, you should watch it. But we wanted to reframe these hot coffee cases and hot liquid cases as cases really about consumer protection and about the policies that exist and the way these scalding hot, it's like lava that I'm handing you. I better make sure it's secure, right? And so it's really about changing the paradigm of how society looks at these cases.
Amazing. Well, thank you for everything you do for the plaintiff's bar, for society, and for doing this presentation. And thank you, everybody, for showing up. This was a wonderful presentation, and we hope to have some more after the holidays. Happy Thanksgiving, everybody, and enjoy the rest of the day.
Thank you all. Really brilliant presentation. Thank you, Henry. Thank you, Justin. Happy Thanksgiving to all. And we appreciate your attending. MCLE will go out later today or by tomorrow. Thanks again. Enjoy the rest of the day and the sunshine.
Thank you, everyone. Take care.
Thank you.